There was an explained article this week on Bhopal gas tragedy. Why the Supreme Court dismissed Centre's curative petition for more compensation. Supreme Court has recently dismissed curative petition filed by the Centre in which the Centre was seeking additional funds from the Union Carbide Corporation's successor, the Dow Chemicals. When the Bhopal gas tragedy happened, the chemical company was Union Carbide. Later, the Dow Chemical bought the Union Carbide Corporation. When the tragedy happened in 1984 and the Supreme Court gave its judgment on the compensation, the company already has paid rupees 715 crore back in 1989. But in the curative petition that Centre filed long back, the plea is to increase this compensation amount to 7,844 crores. The argument that the Centre put forward in the curative petition was that incorrect estimate of total number of deaths, injuries and losses were done earlier. In the previous record, it was recorded that around 3,000 people died and around 70,000 got injured. But the actual number of deaths were 5,295 and around 5,30,000 got injured. So since the figures of number of death and injury has changed and previously environmental damage was not taken into account, and hence the Centre was asking for change in the previous order via curative petition. But howsoever the Supreme Court has dismissed it, we will come to it as to why the petition has been dismissed towards the end of the discussion. And to begin the discussion, we will start to understand what curative petition is. Curative petition is the legal remedy available in India for correcting errors. Number one, and addressing miscarriages of justice. Number two, that may have occurred even after all the legal remedies such as appeals, the review petition, they all have exhausted. It is a last resort measure that can be filed after a final judgment has been issued by Supreme Court. There is nothing beyond curative petition. It is the final binding judgment. The purpose of curative petition is to ensure that there is no miscarriage of justice. And the final judgment of the Supreme Court is not based on any error, on any erroneous understanding of fact or law. Supreme Court recognized the fact that the courts are not infallible, so the errors may come in. But however, to correct the error, there is review petition. And curative petition comes only after review petition, only after all other legal remedies have been exhausted. So if an aggrieved party is dissatisfied by the judgment of a high court, it will appeal in the Supreme Court. And if the party remains aggrieved after the judgment of the Supreme Court, they may apply for review petition. And if they remain dissatisfied even after review petition, then only in certain cases, and those grounds we are going to very shortly discuss, they can apply for curative petition. The concept of curative petition was given by the Supreme Court of India in the landmark judgment popularly called as Rupa Ashok Hurra case. It was back in 2002. Here the Supreme Court accepted the fallibility of court, and hence there was a need for a final remedy to prevent abuse of the judicial process, and hence to cure gross miscarriage of justice. Supreme Court has laid down the criteria based on which curative petitions can be accepted, and it's a very limited ground. One is if there was error apparent on the face of record, meaning while the proceedings of the court has happened earlier, in the previous final judgment, there was some error. Not that new facts have come up. New facts will never be accepted at the stage of curative petition. But if you can prove that the proceedings had some error, that becomes one criteria for curative petition. And the second is the violation of principle of natural justice. One important principle of natural justice is that all parties must be heard. And if the petitioner was not given a fair hearing, if some of the crucial witnesses they were not cross-examined, the petitioner was not given opportunity to present their case properly, if that is proven, then that is the second ground on which the curative petition can be accepted. These are the only two things. We will look at the criteria for review petition, which is a little broader. Review petition accepts the new facts that have come up. Curative petition does not accept new facts because curative petition comes after review petition. So only if there was inherent problem in the judicial process, there were errors which can later be proven, or if the principle of natural justice was violated, people were not given fair hearing, So overall, if the process through which the judgment was given that had error, then you can apply for curative petition. The legal framework for curative petition in India is the judgment of Supreme Court itself. It can also be considered as judicial innovation in India. Supreme Court, for the very first time, as we have already seen, recognized or rather invented the concept of curative petition in Rupa Ashok Hurra case in 2002. And then subsequently through various cases, especially in the death penalty case of 2014, Supreme Court laid down the procedural rules for filing and hearing of curative petitions. Supreme Court observed in 2002 in the Rupa Ashok case that curative petitions are derived from the Constitution's Article 32 and Article 142. It was also made very clear that curative petition is not a substitute for a review petition. Curative petition will only come after all the legal remedies are exhausted, meaning curative petition can only come after review petition. So curative petition is rooted in Article 32 and Article 142. Article 32, as you understand, grants individuals the right to approach the Supreme Court directly for the enforcement of fundamental rights. And Article 142 grants Supreme Court power to do complete justice in any matter and to pass any order necessary for doing so. And this extraordinary power given to the Supreme Court under Article 142 is used in various circumstances, like bringing the cases of inter-river water dispute to the Supreme Court. Right to approach the Supreme Court through a curative petition is necessary aspect of the right to approach the court for enforcement of fundamental rights granted under Article 32. Because in the curative petition, the aggrieved party claims that the principle of natural justice has been violated. That of course becomes part of fundamental right. So Article 32 forms the first basis for any citizen to approach the Supreme Court directly. It becomes a basis for curative petition. The court further clarified in Rupa Ashok Hurra case that the power to entertain a curative petition is derived from Article 142 for the court to do complete justice. But howsoever, you can also look at the connection of curative petition with Article 137. Article 137 actually is for review petition. Article 137 states that the Supreme Court may review any judgment pronounced or order made by it, subject to the provision of any law made by Parliament or any rules made under Article 145 of the Constitution. So review petition directly comes from the power of Article 137. Curative petition may also be linked to Article 137, but Supreme Court in its own judgment has stated that curative petition, they are making that provision from the constitutional provision of Article 142 to be understood with Article 32. Supreme Court has laid down certain rules for filing and hearing of curative petition. Supreme Court has rejected some of the curative petition because they were filed too late. Earlier in giving out the rules, Supreme Court has said that the curative petition must be filed within a reasonable time after the final judgment was given. But what is this reasonable time? This has not been quantified. But it has been understood by the previous judgment that if you go back to the court after a decade, that is not considered as reasonable time. As per the rule, the curative petition must be circulated to the judges who delivered the final judgment, as well as the Chief Justice of India, for consideration of the petition. Then a bench of at least 3 senior-most judges of the Supreme Court will consider the curative petition in chambers, and if the majority of the judges agree that the petition has some merit, then it will be listed for hearing. I must remind you that the review petition goes to the same court, meaning the same set of judges do the review of the final judgment. But that is not the case for curative petition. The ground for acceptance of curative petition has been deliberately kept very narrow. So already mentioned, there has to be a genuine case of violation of principles of natural justice, or there has to be clear-cut error in the proceedings. There has to be error in the record of the judgment, which is actually leading to miscarriage of justice. And the decision of the Supreme Court in curative petition is final and binding. There is no appeal after curative petition. That's where the law of the land ends. Supreme Court, after giving out the concept in Rupa Ashok Hurra case in 2002, in various judgments has actually built up on the concept of curative petition. In Padam Narayan Agarwal case in 2011, Supreme Court has clarified that curative petition is not an appeal. It is a remedy for addressing errors, because the errors would cause grave miscarriage of justice. New arguments are not accepted. If changes has happened in the world and new facts have sprung up, that is not accepted in curative petition. Only if there were procedural errors, only then the curative petition is accepted. In the Subhash Popatlal Dave case in 2012, Supreme Court held that curative petition cannot be used as a tool to re-argue or re-examine the evidence that has already been considered. New facts, new data, new arguments are not to be brought up. Then finally in 2014 in the death penalty case, Supreme Court laid down the rules for filing and hearing of curative petition that we already have seen, and they are very narrow grounds. In 2014 again in the Muhammad Arif case, Supreme Court rejected the curative petition on the ground that the arguments being put forward were already considered and rejected in the review petition. So as such, review petition is final only if you can prove that there were errors in the proceeding. Only then the court will reopen to consider the case. The court will not reopen to consider the judgment, but only to correct the errors. The concept, as you very well understand, began in 2002 in Rupa Ashok Hurra case. And there, Rupa Ashok Hurra could prove later in the Supreme Court that court had relied on unsigned and unauthenticated documents to give the judgment. And that led to miscarriage of justice. And hence the petition was maintainable. And then Supreme Court came up with the idea that if there were procedural errors, there is a need to correct that. Otherwise, it will lead to gross miscarriage of justice. Only then the court can accept the petition, open the doors for reconsideration, and take up the matter. Otherwise, as such, whatever has been given in review petition, that is final. If you remember in the 2G spectrum case, 122 licenses were cancelled. All the licenses, when Mr. A. Raja was the minister, all those licenses were cancelled by the Supreme Court. And that was the case even in the review petition. Then the center filed curative petition. So in curative petition, this will not be reconsidered because this is the final judgment. Cancelled means cancelled. You cannot go in curative petition to reconsider the judgment itself. So center didn't go and challenge this 122 in curative petition. Rather, the authority of the court to enter into the executive domain, that was challenged in the curative petition. And that could have been the error in the proceeding. There's one more important judgment in this regard in order to understand curative petition better. In case Sukumaran versus a state of Kerala case in 2017, a curative petition was filed and Supreme Court accepted the petition and reversed its earlier judgment. Why? Because the Supreme Court found that there has been violation of principle of natural justice as the petitioner was not given an opportunity to cross-examine a key witness. This is an important principle of natural justice that all parties must be heard. So this is a procedural error. This is the heart soul of any judicial proceeding. Now we'll have a quick comparison between curative petition and review petition. You can file for a review petition for various reasons. You can file it for reconsideration of the judgment. You can also file it for correction of an error which is very apparent in the record of the case. But in curative petition, you can only go if there is gross miscarriage of justice, meaning if there have been procedural error. You cannot go again to ask the court to reconsider its judgment. Review petition is based on Article 137 and curative petition, as already we discussed, comes from Article 32 and Article 142. As per the Supreme Court rules of 1966, review petition has to be filed within 30 days. But there has been no time limit specified for curative petition. Of course, the court has said that there has to be reasonable time frame, but the definition of reasonable time frame has not been given. So as such, there is no time limit specified for curative petition. You can go for review petition if discovery of new and important matter or any evidence has come up. And of course, you can go for correction of error, any mistake on the face of the record. But the ground for curative petition is very narrow. You can only go in case of violation of principle of natural justice, leading to miscarriage of justice. The filing of curative petition is before a bench of 3 most senior judges of the Supreme Court. But the filing of review petition, that has to be done before the same bench that delivered the judgment, as far as practicable. If one or more judges have retired, then the filling up has to be done as per seniority. But as far as practical, the review of the judgment is done by the same court, by the same bench, meaning the same set of judges. Review petitions are generally considered as a matter of right. So it is kind of automatic. The judgment has come and then you can file for review petition. But curative petition is not automatic. It is not a matter of right. It is up to the court to open its door for the correction. In the review petition, the court can modify or reverse the original judgment, but it cannot nullify it. But in the curative petition, the court can modify, reverse, or nullify the original judgment. See, in one judgment, there are many orders, and there could be many parties. And as a matter of principle of natural justice, any party can go for review petition. So, based upon the new facts or based upon the proof of error, the court can change the judgment or even reverse the judgment. But it cannot nullify the case, meaning it cannot do away with all the orders that were given in the judgment, as if the matter never came to the court. That will not happen in review petition. You have to give judgment with modification, with reversal, whatever. But you cannot come back to the same situation as it was when the case was not admitted. But complete nullification can be done in the case of curative petition. Now let's come back to the title of the article. Why the Supreme Court dismissed Centre's curative petition for more compensation. Now you understand very well the ground on which curative petitions are accepted. And if the Supreme Court dismissed Centre's curative petition, the two criteria that we discussed must not be getting satisfied. The bench that dismissed the petition, it read out the last two paragraphs of the original main judgment. And it reads like this. It is the union's own stand that the commissioner has adjudicated all claims to the procedure established by law where the possibility of reimbursement was provided. So it doesn't seem to be the case of violation of principle of natural justice because adjudication of all claims were done already. And then the court further says, even so, if the figures of affected persons have turned out to be larger, there is already an excess amount with the center. The 750 crore that was given, all of that has not been dispersed to the aggrieved people yet. Rupees 50 crore is lying with the RBI. This money was given to the RBI in accordance with the Bhopal gas leak disaster Proceeding of Claims Act 1985. So if there is any more demand of compensation, A, this money can be used, and B, India being a welfare state, there should have been schemes for insurance. And since the government didn't have any schemes for insurance, it is liable to pay because India is a welfare state. You take care of your citizens. That's what the court has said. So coming to the original point that curative petition is accepted only if there was error in the proceeding. There seemed to be no error in the proceeding, so curative petition was dismissed. There is an article in the Hindu, millets can be a solution for food nutrition crisis, says PM Modi. There are two aspects to this. One of the aspects has been covered already in one of the previous DNS dated 27 November 2022, where we discussed the importance of millet from various dimensions. The other aspect of it, that is to discuss the importance of nutrition itself and strategies to fulfill the nutritional goals. That we shall do today.
First of all, it is obligation on the state because right to food is a fundamental right. Right to food does not involve only the calorie intake, but the proper nutrients are also important. It is obligated on the state by Article 39A that citizens must be given adequate means to livelihood. It is the duty of the state under Article 47 to raise the level of nutrition and standard of living and to improve public health. So it is the part of the contract between the citizen and the government. This is an obligation on the government. So this can be your GS paper 2 argument. If you talk from GS paper 3 perspective, human capital is the most important resource asset of any nation. Economic Survey 2019-20 has noted that food is not just an end in itself, but also an essential ingredient in the growth of human capital and therefore important for national wealth creation. We have empirical evidence to show that children with undernutrition or anemia, the iodine deficiency, they have low IQs. They have lower productivity as adult. When they will participate in the labor market, they will not be contributing very efficiently. According to the World Bank estimation, if we reduce our high prevalence of stunting rate, the GDP will rise by 4 to 11%. The good nutritional status of the present generation and even more of our children is very important to reap the benefit of demographic dividend. With prevailing level of undernutrition and lack of good health, the society cannot remain healthy. The International Labour Organization's declaration in Philadelphia in 1944 states that poverty anywhere is a threat to prosperity everywhere. UPSC has given this as a topic in the essay paper in 2018. This is looking at things from the perspective of GS paper 1. But the paradox in Indian context is, despite decrement in the level of poverty in recent time, the nutritional status has not improved proportionally. Around 270 million people have been lifted out of poverty from 2005-6 to 2015-16. This is a huge number. But despite this, malnutrition has not declined much. Prevalence of undernourishment still remains very high. There are many other paradoxes. For instance, low-income states like Chhattisgarh and Odisha has done much better in reducing the level of undernourishment than the better performing high per capita states like Gujarat and Maharashtra. This clearly indicates that malnutrition is a very complex problem, and nutritional governance is very important in this regard. Because Odisha, which is a low-income state, has done much better in decreasing the prevalence of undernourishment. This has been made possible because of a better network of integrated child development services. Public health facility has improved and the number of workforce in the public health sector per lakh population has increased. Odisha also has worked towards the educational attainment of women. These holistic measures have resulted better nutritional status in the state. So the issue is regarding governance. The issue is about maternal health, the maternal educational level. It is not just about income. Because in higher income states like Haryana, Gujarat, Punjab, the status of tribals, people in rural region with poor background and children of illiterate mothers is not good. See, food comes from agriculture and 3/5 of rural population are engaged in agriculture. But still the fourth round of National Family Health Survey suggests that malnutrition rate are higher in the rural areas. On the outset, this seems to be a paradox. The problem is very complex. The problem is also related to diversification of agriculture, which is not happening because of policy reasons of government and other reasons. Malnutrition is not just about undernutrition as we have observed in the beginning. It is also about overnutrition, which is a paradox in itself because when large part of population is grappling with undernutrition, many people are also facing the problem of overnutrition. According to the National Family Health Survey 4 data, nearly 1/5 of adults in India are either obese or they are overweight. So what is the solution to this humongous problem of malnutrition in India? As we have discussed, the problem is multidimensional, and looking at it from one angle, one lens, one prism will not solve it. We need to have convergent action plan to solve the problem of malnutrition. For instance, there must be an annual integrated report that encompasses health, nutrition, the performance of Swachh Bharat mission maybe. The report may also include the diversification in agriculture sector, maybe also the educational attainment by women or the maternal health, and implementation status of flagship programs like Poshan Abhiyan. Once we start to look at it comprehensively, then only a convergent, coherent action will make it possible to increase the nutritional status of the nation. Similarly, national agricultural policy must also be aligned with the national nutritional objectives among various initiatives like Poshan Abhiyan. Similarly, ICDS, Integrated Child Development Scheme, which is very crucial in improvement the nutritional status not only of children but actually of adults of future generation. This begins focusing on children from preschooling level, and there is growth monitoring of children at the Anganwadi centers targeting children from 3 to 6 years. This is considered to be a very good governance intervention to improve the nutritional status. But however, for a better output, it must be clubbed with more home-based contacts, like for example, communication with mothers who are having children from 3 months to 2 years maybe, to ensure compliance with infant and young child feeding practices. For example, ensuring breastfeeding at early stages. All in all, what is required is a convergent action plan and not working in different initiatives and programs in silos. After policy and action plans, what do you talk about? You talk about specific government tools to improve the implementation of those policy vision. For instance, we must have a national nutrition surveillance system. Just like we have for pollution, we have for forestation, we also have mapping of soils. Many states are doing mapping of mineral resources, water reserves. Similarly, there must be a mapping of nutrition and a surveillance mechanism. In governance, we require coordination among various institutions like Panchayati Raj institutions, public distribution system, public health departments, accountability, transparency. The tools of governance, they must be strengthened to improve the implementation of important programs like ICDS. Similarly, other tools for example, social audit, which is independent of annual audits and other government mechanisms. After policy and the general governance mechanism, what you talk about concerning any issue in GS paper 2 are the specific measures, the schemes and initiatives of government. Much of children undernutrition are caused by illness. Diseases like diarrhea, pneumonia, measles, they decrease the ability of the body to uptake nutritional elements. And these diseases are caused because of poor sanitation and lack of clean drinking water. In this regard, you can mention the implementation of measures government already has taken, for example, the WASH initiative, greater coverage of immunization, and celebration of village health sanitation, nutrition days, things like that. For example, Nutrition Month has been initiated by Government of India. Similarly, at local level, nutrition days, village health sanitation days, these must be celebrated to increase the awareness level. Then from GS paper 3, you can suggest that food fortification measures must be taken up and industries must be incentivized to do it. Then from GS paper 1 perspective, you can suggest that the status of women in the society is very closely linked with the nutritional status of the society. Female literacy is very important. That is related with birth spacing in children. That is also related with delay age of marriage and awareness of exclusive breastfeeding for the first 6 months. Maternal health is also very important because fetal growth is restricted if the health of the mother is compromised. Then malnutrition also has the angle of societal inequality. It is seen that girl children are more malnourished than boys, and the lower caste children are more malnourished than the upper caste children. So social inequality also has to be removed if malnutrition has to be removed. United Nations World Food Programme has got the Nobel Peace Prize this year. And this must bring attention of the world on the issue of nutrition and health. And India must also seriously consider to re-strategize in order to effectively deal with the issue.
There is an explained article on same-sex marriage. As you would be aware that Supreme Court has formed a constitutional bench to discuss the legality of same-sex marriage. A petition was filed in the Supreme Court under the Hindu Marriage Act and the Special Marriage Act. This petition was filed in the court after the same-sex marriages were not being recognized by the government even after Supreme Court decriminalized the consensual homosexual acts. And the center opposed changes to any existing laws related to marriages. Section 377. This erstwhile section was part of Indian Penal Code. It used to make sex or marriage with persons of same gender a punishable offense under law. But in 2018, Supreme Court in Navteej Singh Johar case decriminalized consensual homosexual sex, effectively striking down Section 377 of IPC. But mind you, entire Section 377 was not struck down. Section 377 also had provision for making bestiality as a punishable offense, and that has remained intact. The central government has submitted in the Delhi High Court that any interference with any marriage laws will cause a complete havoc in the delicate balance of personal laws in the country. They have said that living as partners and having sexual relationship with same-sex individuals is not comparable with the Indian family unit concept. In the concept of Indian family unit, there is a husband, a wife, and children. And this concept necessarily presupposes that a biological man is the husband, a biological woman is the wife, and children are born out of their union. Registration of marriages will also become problematic. Because if you go to register your marriage, you'll have to prove that ceremonies and rituals were done in the marriage, unless it was a court marriage. And the traditional ceremonies and rituals cannot be done in the same sex marriage. So the center has submitted that all statutory provisions will become unworkable. It is also their contention that in the 2018 Navteej Singh Johar case, Supreme Court decriminalized homosexuality. But the stand of the center is that this judgment, it did not legitimize homosexuality. It only decriminalized it. Recognizing same-sex marriage will actually legitimize it. However, there are many Supreme Court judgments which actually has laid the foundation for the same-sex marriage. In the Putta Swamy judgment, the constitutional bench declared right to privacy as a fundamental right. Right to privacy was made part of right to life and liberty. UPSC in 2018 has asked in the mains exam, what is going to be the consequence of this judgment? Putta Swamy judgment has been the pot from where many judgment took roots. Aadhaar judgment is based on Putta Swamy judgment. Hadia judgment was also based on the Putta Swamy judgment. Navteej Singh Johar case can also be strongly linked with Putta Swamy judgment. Because privacy of an individual recognizes an inviolable right to determine how freedom shall be exercised. And choosing one's partner, that's also part of liberty under right to life and liberty. So any intimate act and matters related with marriage, they all are covered under privacy. So they all are fundamental right. In the Hadia judgment, Supreme Court observed that intimacies of marriage lie within the core zone of privacy. The choice of a partner, whether within or outside marriages, lies within the exclusive domain of each individual. Supreme Court already has recognized living relationship as good as marriages. In one of the judgment last year on interfaith marriages, Supreme Court observed that matters of dress and of food, of ideas and ideologies, of love and partnership are within the central aspects of identity. The court further said, society has no role to play in determining our choice of partners. Supreme Court reiterated the stand it took in Sabrimala judgment and other judgments previously. It said the Constitution protects personal liberty from disapproving audiences. The social values and morals have their space, but they are not above the constitutionally guaranteed freedom. These are very important observations of Supreme Court from various judgments that you must put under your belt. In Sabrimala judgment, Supreme Court previously has said that individual freedom prevails over purported group rights. Individuals cannot be forced for social conformity. Individual freedom, liberty, choice of partners, intimacies under marriages, they all are part of fundamental rights. And hence, although not explicitly said by any judgment of Supreme Court, these observations naturally lays the foundation for same-sex marriages.